Very well, you can give it. About you are also asking for time. Item 22. So you have to file in all three.
Yes, sir.
And you also in all three. 24. 2 weeks time as spread for is allowed to learn counsel for the respondent GSTN.
For 3 weeks time.
Jamshedpur, as you said, I thought it would be going to Coimbatore or some other place. Very well, we'll give you 2 weeks time. The matter will come after 3 weeks. So arrange amongst yourselves. 2 weeks time as prayed for is allowed to learn counsel for the GSTN and the state to file counter affidavit. Yep, GSTN in counter affidavit in all the matters, and 2 weeks to learn counsel for the state to do so in WPT 4574 of 2020. Stop. Matter will be listed in the week of 4th April. 4th is a holiday or what? Huh? 5th April. The week of 5th April. So that petitioner, if so advised, may file rejoinder there too in the meantime. And if any other adjournments? In item 13, who has prayed for adjournment? Mr. Kushwaha? You, on your repeated mentioning, it was listed. Then who has prayed? Why is the state not? Last week also perhaps one or two matters. Where is the state council? We want to know why he wants an adjournment. Pleadings, everything is complete. You have informed the state before mentioning it also.
Yes, sir.
Then at the last moment,
from the daily causes under the heading for orders which affects item 1 WPT number 798 of 2022. Mr. Nitin Kumar Prasad.
So, my name is page 23. There is one word missing in the right copy. It was not very legible, starting language term. Page 23. Look at the top line of the page.
so you remove it. There are 2 more pages perhaps.
All the rest of the type copies have been given. The type copy of page 23 has been given, but since one word is not very legible, so that have not been typed. There is a blank in the type copy.
deliberate intention to
realize the due. Realize. It is realize.
to realize the
To realize the undue and not admissible surrender. Yes, utilize is the word which is missing. Utilize.
so you remove it now.
Because during the course of the day, I remove it.
You remove it now.
College may create it today. There is an urgency. Otherwise, I would not have persuaded her in this one. Very
Defective
limited facts, very limited facts.
So your appeal has been restored and you fear coercive action.
No, it's not what has happened in this matter. Looks as against the order passed in Ohio, looks order is originally approached the learned tribunal. Since the tribunal was not functional at that point of time, and there were certain bank account attachments were going on, we approached this honorable court. This honorable court, taking into consideration the nature of dispute, gave us a stay. Because I have an experience. Now, during the pendency of my petition, the SASTAT started functioning. My stay was vacated, the direction was issued to SASTAT that you hear it on merits as well as on the interim application. Once interim application was heard, I was directed to deposit 10%, I have deposited 10%. That fact is not there on record, I brought it, I paid it. Now, after that, a date is fixed on 29th of September 2016. The notice is received in my office on 3rd of October. And on 29th of September 2016 itself, my appeal is dismissed for record. Soon,
It is restored now.
we filed a restoration application. But again, it was said that it became non-functional because there is a single judge now. So it could not be restored till yet my restoration application is pending. Now, pending my restoration application, since the appeal has been dismissed for default, now a notice for recovery has been issued. Now, all that I am trying to say and persuade is
No. So once the appeal has been restored,
no, it has not yet been restored. It is
you
pending.
have already filed a restoration.
Yes, I have filed a restoration application. My restoration application is pending.
And you had got a stay by the SASTAT
Yes,
earlier,
issued.
after it was released from this court.
Yes. And I deposited 10% because I have the document, but since it was an old matter, the department also did not have much of a document. Because we have deposited 10% because in 2004 there was an amendment which was carried out that in order to maintain an appeal, an assessee has to deposit 10%. Because the wiring was challenged by the just 0% and approval, and thus it was affirmed of the Supreme Court that yes, this pre-deposit is mandatory, it cannot be appealed. So we deposit 10%. Now, today what we are saying is that because of this actual difficulty, because the bench is not available, that we are unable to get it restored, although we have been pursuing it.
May I just make a request before the last case is this file has been handed over to the morning because it has been transferred to the senior. So let this matter be the first day of the conference, then my senior will assist the conference.
First day?
First day after the holidays or tomorrow because my senior
Yes,
is not
tomorrow I
able
have difficulty because I am not in Lucknow.
because he has not been able to go through the file also. Today morning he has reported because the file has been transferred to our office.
So in that case, to accommodate both of you, we can take it up as the last case.
Yes, ma'am. No difficulty.
Tell your senior to go through it.
Because my senior has already, I just have a complaint because he has raised his total of 5 days.
Wherever. So before we finish off this list,
case as the last case.
we will take
Okay,
it up.
I'll just inform you.
You have heard him. This is the small matter. Pending restoration, recovery is likely, though there was a stay by the SASTAT.
Yes. And we have deposited this money on 4/9/2015.
All what you have said are there on record or not?
It is all around record. So far as this A application, this pre-deposit is concerned, this we would not bring on record. The pre-deposit money.
No,
But they are
pre-deposit.
aware about it. The department.
Only after pre-deposit did you get a stay.
Yes, yes.
So that stay order is there in this.
No, it is not there. It is not there.
You get it through email or
That stay order at least should have been part of it. Your case is built up on that.
It's the only difficulty which we are facing. Matter pertains to 2006-2007. So many officers have changed. The files have been going here and in Calcutta. So that is the difficulty.
No, that's not an excuse. In the absence of a very vital order of the SASTAT giving you stay, how can we appreciate your contention? So we'll take it up as the last case.
जैसे तो नॉर्मल है स्टेट था डीएफडी
So you remove the defects, then counsel for the petitioner, Mr. Nikhil Kumar Kusari, undertakes to remove the surviving defects during course of the day.
Next. Item 2, WPT number 1031 of 2022, Mr. Sumit Gurudia for the.
In fact, two also are removed all the defects. Achha. 2, 3, 10, 11 all are together.
Yes. Three were really for defect. Only that nomenclature thing which I just satisfied what you were. But 10, 11 were completely ready with that nomenclature.
Very well. काफी कॉल करिए.
For orders, item 4, civil review number 53 of 2019, along with item number 5, Mr. Mahesh Tiwari, Mr. Pradeep Kumar Verma for the petitioner.
Earlier occasion, also the minister direct us for a copy of all the also for petition contempt. But in both our cases are likely one of the same matter. We have sometimes talking about the Friday itself. Today the matter is also contempt is also appearing on the.
So, Mr. P.K. Verma, Pradeep Kumar Verma is appearing. Where is he?
We have the copy.
His junior, Miss Vandana Sinha, she normally appears.
Serial number 5. 4 and 5.
You are for the petitioner in item 5.
Yes.
You appear in item 4 also. File your wakalat number.
4 to 5 and
So when will you file? When will you file wakalat number?
will file
Okay.
and will file after.
Counter in civil review may not be required. Then counsel, your good name?
Rajni Singh.
Rajni Singh, AC to Mr. Pradeep Kumar Verma. And counsel appearing for the petitioner in contempt civil 187 of 2019 undertakes to file wakalatnama today itself on behalf of the same party who is respondent opposite party in civil review 53 of 2019. Stop. She prays for 2 weeks time to file counter affidavit. By tomorrow. Stop. List the case after 2 weeks so that the petitioner list the case after 2 weeks. Let the name of the learned counsel appear in the cause list for the opposite party on filing of wakalatnama.
Item 6, first appeal number 81 of 2020, Mr. Abdul Kalam Rasidi for the appellant.
Okay.
And very next year, the general is particularly forced and after that the problem
So your suit has been dismissed. Issue notice on the respondent under registered cover with AD, speed post and ordinary process for which requisites be filed within 1 week after opening of holy holidays. Failing which the appeal shall both on limitation matter IA number so and so and on the main. Failing which the appeal shall stand dismissed without further.
Item 7, WPT number 177 of 2021, along with item number 8 and 9. Mr. Nitin Kumar Prasad.
This one we will keep it on 22nd. It's not yet ready. Post the matter on 22nd March 2022 under the heading for orders.
Item number 10, WPT number 1018 of 2022, Mr. Sumit Guru.
saying that this matter may not be a WPT because toll tax in the
First, some of the defects, let us see if they are ignorable or curable, whatever.
item number 2, my lord.
Yes. It's nice to see all of you bubbling with energy in a physical court.
Actually, it has got a difference in physical. So far as arguments are concerned, you have to
Actually,
persuade your lordships a little more.
human beings are social animals, so they need to socialize, be present.
So far as Ratan Stone was the first matter is concerned,
Yes.
there was some defect relating to type copies, which we had already filed. And in one online copy, page 86 was not arranged properly as per that, but not the physical copy is absolutely arranged properly.
So these pages you have filed.
Yes, these type copies have already been filed on Friday itself.
Learned counsel for the petitioner, Mr. Sumit Garodia, submits that defect number 1 has been removed by filing the relevant legible typed copies of the relevant pages. Stop. In respect of defect number 2 concerning page number 86, the same has been properly arranged in the hard copy. Stop. The other defect, surviving defect, is in relation to maintainability. Stop. As such, defect number 1 and 2 stands cured. Office to verify. Yes. Next.
Item 3.
3, what is the defect?
Only the effect of maintainability. There is no
Okay, very well. Keep it here.
Sundar Sahib.
Yes. Then item 10, there is
10 also, there was one type copy which we have
4 में लिखिए let WPT number 1031 of 22, 1059 of 22, 1018 of 2022 and 1019 of 2022 be all be tagged together as there is common issues. Stop. Where of लिखिए in WPT number 1018 of 2022, Learned Counsel for the petitioner submits that the defect relating to page number 55 has been removed by filing the typed copy. Stop. The other defect relates to maintainability. Yes. 11.
Item 11.
WPT 1019 of 2022, Learned Counsel for the petitioner submits that defect number 1 relating to supply filing of typed copy of page number 56 and 88 have been removed by filing. Stop. Office to verify. The other defect relates to maintainability of the writ petition as per its nomenclature, WPT. Yeah, maintainability of the writ petition as WPT matter instead of WPC. Yes, which one do you want us to take up?
101 is a convenience compilation. Maximum position is absolutely nil. All we have brought it all the files. This is getting your social output, majority of it is as a group.
And that is what the office has also. So we will first hear him on maintainability.
Straight away on the question of maintainability, the office will see Article 366(28), or the definition clause of the word taxation.
Constitution.
And Mr. Sinha is also looking in the matter. We both are working together.
All stone quarry litigants.
It is like double barrel gun operating lot against who are still conflict. Double barrel gun.
Like gun operating against a cannon.
Why have you have stated in your petition that you are contemplating to challenge the virus of the composition fee?
So that is all a separate matter when we show to your office the amendment rules. That is purely on the question of virus that you will show being prepared. But on this note, even without the virus note, the present action is
366.
366(28).
Taxation includes the imposition of any tax or imposed, whether general, local, or special.
Includes any tax or imposed, whether general or local or special, and tax shall be construed accordingly. So, any imposed for the purposes of for the definition of taxation would be covered by the definition of taxation. Any impost would be in the nature of a tax, which would be covered by the definition of taxation. Your Lordship, High Court rules for Rule 34. The word used is
गदर की बोले में ये टेबल जो है उधर भी लगाने बोले कि किताब सब रखने के लिए 34.
yes, Rule 34, Rule 2, my lord.
Yes.
The following matters may be heard and disposed of by a division bench. We are not concerned with 1. 2. All writ petitions C relating to taxation matters. The word important is taxation.
Yes.
Now, taxation is defined under the Constitution, Article 366, sub-Article 28, which I have just read to your.
Yes.
And this is precisely been interpreted by the Honorable Supreme Court under the same article. I have given that judgment under the first judgment of my compilation, page 1. from para 16 to 22, but Lord, may I just refer straight away para 18.
Para?
Para 18, Lord, page 6 of my compilation. Lord, I just in this I am referring it only for the purpose of showing that the definition of taxation as provided under Article 366(28) was quoted at the next page, Lord. Then, Lord, may kindly come to para 19.
In fact, I was going to ask you as to where the expression fee is used in the
So
Constitution.
it is not used. That is
No,
what
no,
yes.
this paragraph says there are two places where fee has been.
Yes, yes. Two places in the article it has been used, yes, but it is not defined. I'll read this paragraph.
This question was asked to me, if Mr. Indrajit Sinha would remember, in the MADA matter by Chief Justice Bhagwati. Immediately I answered, the Lordship was very happy and surprised to know. Because this is quite rare to find out.
I read this one. The
Yes.
expression taxes and duties are to be found in many provisions of the Constitution. The expression fee finds a place in Articles 110 and 119 of Article 2, which are in para materia. Both the article recognizes the existence of two kinds of fees: fees for license and fees for services. Each one of the three lists contained in the 7th schedule have entries which employ the expression fee. Entry 96 of list 1, entry 66 of list 2, and entry 47 of list 3. Article 366 contains definition of various expressions employed in the Constitution. Article 366(28) defines the expression taxation.
Yes.
I read that one again. Article 366: taxation includes the imposition of any tax or impose, whether general or local or special, and tax shall be construed accordingly. The expression fee and duty are not defined under the Constitution. Article 366(28) employs the expression imposed. What are the legal contours of each one of these expressions? Tax, impose, duty, and fee fell for the consideration of this court from time to time. This court in McDowell versus so and so held. Tax, duty, cess, or fee constituting a class denotes various kinds of impost by the state in its sovereign power of taxation to raise revenue for the state. Within the expression of each species, each expression denotes different kinds of imposts depending on the purpose for which they are levied. This power can be exercised in any of its manifestations only under any law authorizing levy and collection of tax, as envisaged under Article 265, which uses only the expression "no tax shall be levied and collected except authorized by law." It is in its elementary meaning conveys to the support a tax legislation action is essential. It cannot be levied and collected in absence of any legislative sanction by the exercise of the executive power of the state under Article 73 by the Union or under Article 162 by the state. Under Article 366(28), taxation has been defined to include the imposition of any tax or impose, whether general or local or special, and tax shall be construed accordingly. Imposed means compulsory levy. The well-known and well-settled characteristics of tax in its wider sense includes all imposts. Imposts in the context have following characteristics. The power to tax is an incident of sovereignty. Law in the context of Article 265 means an act of the legislature and cannot comprise an executive power or rule without express statutory authority. The term tax under Article 265 read with Article 366(28) includes impost of every kind, namely tax, duty, cess, or fee. And then, Lord, this was the precise question also, para 21, Lord, it was contended in this case that fee was levied, but will not come within the purview of Article 265. This is answered. A 9 judges constitution bench in the case of Jindal versus so and so quoted the above mentioned statement of law with approval. Therefore, it is now well settled that the expression fee is also comprehended in the expression tax for the purposes of Article 265 and even for the collection of a fee. Authority of law, that is legislative support, is mandatorily required under the Constitution. In view of the aforementioned authoritative pronouncement, we need not examine any ancillary question. Now, we have the toll tax is by way of a specific entry in the Constitution, entry 59.
Yes.
So now, if we say it is an impost in exile of the sovereign power under entry 59 by the state government, and that imposed in the nature of the in view of the definition of taxation is covered it's taxation, any impost is a taxation, and in terms of rule 34 sub rule 2 of the High Court rules, it becomes a taxation matter to be heard by the Honorable Division.
Then in that case, under the present structure of the High Court rules, all kinds of fees which are by a statutory backing becomes
it should be an impost
writ petition maintainable before the division.
In fact, we both deliberated on this before filing a WPT, whether it should be a WPT or a WPC.
So on this question itself, we need to hear the other side in detail, because this will change the entire structure of allocation of business.
Yes, that's true, but I may only worry if you see my compilation for
and otherwise you have an equally good remedy before single judge if it is treated maintainable as
yes, correct, but in this nature, since the toll tax and the very nature of the levy itself, it has been subject matter of further interpretation by the Supreme Court, that it has to be good pro quo, it cannot be in the nature of a general revenue of the state. If your options may just see our anxiety in the matter, in my compilation itself.
In your writ petition also, at para 26, you have considered it in the nature of a fee or an impost with a quid pro quo element, which is the first attribute of a fee. So, but even if that be there, still you say that by virtue of this judgment, it comes under the definition of an impost, which is a tax under 366(28).
Yes. In fact, our specific plea is, we have given two judgments to your options, One, our specific plea is that the very impost, the present impost, is in the nature of an additional toll tax, which is being levied only on mineral-bearing vehicles. So at one point we have taken that this levy of toll tax only on mineral-bearing vehicles in the form of composition user fee, whereas this is the nature of an additional toll tax, and we are covered by one direct judgment of the Honorable Supreme Court on that point. With the fruit-bearing vehicles and other things were levied, dry fruits were levied additional toll tax only on the dry. The Supreme Court said you can't do that. Second the judgment is with respect to that it should be quid pro quo, the line of judgment which I have shown. But if your lordship should just on a prima facie on the present context itself, if your lordship should see, but what is the rule, if your lordship should just see with us for one moment, how they have framed the rules and what is the intent of the rules. But the rules I have brought to your lordship's kind notice, but it's at page compilation, page 104. Kindly see the rules, at page 104. Sorry, page 129 is the rule, the present rule.
Yes.
I read the rule composition user fee where it is defined at the bottom. Composition user fee means the levy of consolidated user fee for use of state roads and or commuting on roads and of bridges, including interchanges, flyovers, ROP, RUP, bypasses and tunnels thereon in mining area for such period and on such condition as may be specified under this rule, in addition to the user fee payable under Rule 3 of these rules. And then your mining area में what is the definition next page? It's wide enough to cover anything which is having a mineral bearing or anything. I just read that. Mining area for the purposes of this rule shall mean all such area falling under the Mines Act, JMCC Act, the Jharkhand Mineral Prevention Transportation Storage Rules, including the area falling for the purpose of washing and processing of mine goods, loading, unloading and transportation of all such mine goods, whether or not falling within any local area, and as specified in this behalf. And then what important is, what may I just first come to composition user fee and then I show the user fee. Page 131 is composition user fee.
Yes.
Notwithstanding anything contained in Rule 3 of these rules, the state government may, by notification in the official gazette, in addition to the amount of user fee payable under this rule, provide for a scheme for payment of composition user fee for such period and payable by all such mechanical vehicles which are liable to pay user fee for use of any state road or part thereof for commuting in mining areas as the case may be, subject to such conditions and restrictions as may be specified and or as prescribed in this behalf. My first contention is that there is no notification as yet issued prescribing the scheme for levy of composition user fee.
Anywhere in the
No,
state.
anywhere in the state. They have not issued any notification as yet. Now, I kindly then come to just above this.
No notification specifying the section of that state highway in which composition is.
That is 3.2. There are 2 points which we are taking. Kindly see sub-rule 3.2. Just at the top at page 131. The collection of user fee as levied under sub-rule 1 of Rule 3 shall commence from such date as is specified by a notification in this behalf from the date of completion of the section of the state road. So this has not been issued. Neither for a notification has been issued under Rule 3A1. And in this Rule 3A1, a proper scheme was to be notified, and the methodology which was notified. Now, what the mining department has done, and on the report on what they have done is, kindly come to page 133. Kindly come to 133. This is an enabling provision which was given in the rules, amendment rules, that as to how the collection of collection of user fee was by way of a toll plaza. So they have said that now collection can be also made online through e-challan and at the time of generation of challan. So far as mineral bearing vehicles are concerned, the mining department was made as in the rules were made as the authority to implement it. That is Rule 7 sub Rule 1. May I just read that Rule 7 sub Rule 1? खान एवं भूतत्व विभाग द्वारा खनन शुल्क हेतु चालान ई चालान निर्गत करने की प्रणाली है। उप प्रणाली में खनन क्षेत्र में मिनरल कैरिंग कमर्शियल व्हीकल से यूजर फी को समाहित करने हेतु खान एवं भूतत्व विभाग के माध्यम से कार्रवाई की जाएगी। So this is an enabling provision. Now, without any notification under sub rule 2 of Rule 3, without any notification under sub rule 1 of 3A1, but what the director has done is, he has straight away issued a letter at page 136. You may kindly see. This is the letter which he says through the GIMS portal, the entire collection will be made. उपयुक्त विषय के संबंध में कहना है कि पथ निर्माण विभाग झारखंड रांची का निर्गत अधिसूचना संख्या the amendment rules which I just read द्वारा लागू किए गए खनन क्षेत्र में मिनरल कैरिंग कमर्शियल व्हीकल से कंपोजिशन यूजर फी का उपग्रहण किए जाने हेतु जिस पोर्टल में मॉड्यूल प्रावधानित किया गया है उस व्यवस्था 2 चरणों में लागू की जानी है। प्रथम चरण में जिस पोर्टल में अंकित ट्रांसपोर्टर व्हीकल ओनर द्वारा अपने लॉगिन आईडी से वन टाइम पिन जनरेशन किया जाना है, जिसका प्रावधान जिम्स में किया गया है। जनरेटेड पिन को ट्रांसपोर्टर व्हीकल ओनर द्वारा वैध यूजर आईडी के माध्यम से सुविधा अनुसार बदला जा सकेगा। उस पिन का उपयोग प्रस्तावित मॉड्यूल के द्वितीय चरण में ऐसी डीलर द्वारा चालान निर्गत करने के समय वाहन के पिन वैलिडेशन की प्रक्रिया के समय किया जाना है। अतः सभी खनन पदाधिकारियों, डीलर, अनुज्ञप्ति धारियों, ट्रांसपोर्टर एवं वाहन मालिकों को जिस पोर्टल पर लागू किए गए प्रथम चरण के मॉड्यूल के अनुसार अपने वाहनों पर पिन जनरेशन की कार्रवाई 1 सप्ताह के अंदर सुनिश्चित करने हेतु अपने स्तर से निर्देशित किया जाए, ताकि भविष्य में प्रस्तावित द्वितीय चरण मॉड्यूल में पिन वैलिडेशन की प्रक्रिया पूर्ण हो, जिससे ऑनलाइन जिम खनन चालान व्यवस्था निर्बाध रूप से संचालित रहे। उक्त के संबंध में फ्लोचार्ट इस पत्र के साथ आवश्यक कार्रवाई हेतु संलग्न। And with effect from 1st February 2022, they have implemented this module. And now, just to show by way of example, if the lordship may come to page 140. This is all from the part of the readings of the writ application. But this is the GIMS portal screenshot which we have annexed. Now, on each and every generation of mining challan,
Yes.
amount of rupees 1200 is being charged. Now, the other point which is there is even my crusher is situated in 1 kilometer distance from my mines, but I have to take minerals to my crusher which I manage those mining challans. Even for that one grade, 1 kilometer of 600, 1 kilometer, I have to pay 1200 rupees without there being any road also. It's a road, it's not even a village road there. But the point is 1200 rupees they had provided in the portal which was showing as due. But now they have not stopped here. Once we have filed the writ petition, maybe what otherwise they would have done it. But kindly see the notice at page 146. Similar notices have now started coming and they say you pay it, otherwise you will stop the generation of mining challan. The entire business would be crippled. Page 146. मुख्य प्रासंगिक पत्र के संबंध में कहना है कि पथ निर्माण विभाग झारखंड रांची के द्वारा निर्गत अधिसूचना द्वारा लागू किए गए कंपोजिशन यूजर फी के उपग्रहण हेतु खनिजों के परिवहन ढुलाई में लगाए गए सभी वाहनों मिनरल कैरिंग कमर्शियल व्हीकल का पिन जनरेशन की कर खनिजों की परिवहन ढुलाई की गई है। इसके बाबत कंपोजिशन यूजर फी का भुगतान आपके द्वारा अब तक नहीं किया गया है एवं खनिजों के परिवहन ढुलाई में लगाए गए सभी वाहनों मिनरल कैरिंग कमर्शियल व्हीकल का पिन जनरेशन के पश्चात वाहन का वाहन पोर्टल में सिंक्रोनाइजेशन नहीं किया गया है। उक्त के आलोक में निर्देश दिया जाता है कि अविलंब आरसीडी कंपोजिशन यूजर फी के भुगतान एवं वाहन पोर्टल से सिंक्रोनाइजेशन करना सुनिश्चित करें, अन्यथा जिम्स पोर्टल के माध्यम से चालान जनरेशन पर रोक लगाई जा सकती है, जिसके जिम्मेवार आप स्वयं होंगे। So, the effect, net effect of this GIMS portal, which they have done without even any authority of law, is that the entire business is otherwise crippled because it's a switch on and off, like in the online portal. It becomes a complete coercive action against us, but we can't do our business only because we can't transport a single in terms of the routes also.
Otherwise, also, if the nature of this impost is considered, is it in the nature of a fee actually?
No, we have a specific stand that it is in the nature of a tax, in the nature of an
because
additional
you
tax.
are not going to get any quid pro
Benefit,
quo.
yes.
It's, as far as I read somewhere in the notification, this is being levied to ensure that the roads are repaired time to time.
That I just showed you.
The roads are to be repaired for use of all, including the
Section 2 of the Act. It says that you will only levy on a state road maintained and repaired by the state.
Even in the rules also it is there.
Now what has happened, they have defined a mining area. The mining area is inside my mine also. Even if I commute, and they are very cleverly use the word commuting in mining area. So even if I am commuting inside my mining area, I will be automatically charged. The moment the transit permit is generated, as Mr. Lord says, for 1 kilometer also, I will have to pay 1200. And it's nature of a tax because it is to and fro composite. Even if the vehicle is not carrying the mineral, it is coming to a mine to pick up mineral, it will have to pay. So therefore, to that extent, there is no quid pro quo so far as mineral carrying vehicle is concerned. And according to the wiring matter, we are developing that it is not a tax or a toll or fee on the vehicle, it's a tax on the mineral. So we have specified, singled out a mineral and only charging on mineral in the garb of transportation of mineral. Transportation of mineral is also covered under the MMRD Act. Your jurisdiction is completely taken away. 23C is the rule regulating transportation. There is a rule framed by the government of Jharkhand. All these facts are there. The only thing is that in terms of this is a pre-constitution 1851 Act. In terms of Article 372, it continued. It becomes subject matter of list 2. All states have subjected it to amendments time and again. Jharkhand government also amended it. But the main act has not been amended. Section 2 is the parent provision. The rules go beyond it. So today, I don't know whether you are aware, on a mineral carrying vehicle for transport of mineral, if it is from a forest area, I am paying 1 rupee to the GIMS portal, 1 rupee. 57 rupees for forest transit permit and 1200 rupees additional on this. So minerals is going to, and it is encouraging illegal mining. It is absolutely encouraging illegal mining. No one wants to transport under a permit. They will transport without a permit. You can't single out a product and make it so cumbersome to do business that people will start doing illegal business.
And suppose a vehicle loaded with mineral is coming from outside the state to deliver that, they don't have to take that challan from the GIMS portal.
No, they don't have to take that challan from the GIMS portal.
And what is the essential difference between that toll fee and the composition user fee?
It makes it compulsory 200 rupees. For user fee, there is nothing prescribed. What is the user fee? No, once it's making composition user fee 1200. Yes.
So the nature of toll tax or toll fee is basically to recover the amount spent on
As being paid.
everywhere. How much is the expenditure for construction of that road, that is being recovered as a toll tax.
The moment it is recovered,
Stop. That happened in the case of D&D.
Yes. Unless the government says, no, I will maintain and keep on repairing it, I will take the repair. That's all. It's a distribution of everyone. Now you have to say in 2011 rules, there was classification vehicle wise.
Yes.
LMB, HMB.
Page 106, what my friend was saying, just to point out, but even this particular notification prescribing the rate at the rate of 1200 is even beyond their own earlier rule of rule 4 of the earlier 2011 rules, which was in the module that whatever is the collection to be made is proportionate to the cost, which is at page 106, and that rule 4 has not been amended.
Mr. Who is State Council? First of all, what do you have to say on the maintainability and then rest of the argument?
All these little matters,
That will be the burden of the division bench.
all matters will not come to the rule division. So, commissioner and the system because we have to be inspector. And
have you notified the scheme and the section of the highway in which
everything is there in the BRT. And it's no problem with the road itself. There are first of all, you have to write it in page 29, next to your all the first 1019.
Yes, 1019. Yes?
The composition user fee means the levy of composition user fee for use of state roads and or commuting on roads and or bridges, including interchanges, flyover, ROE, bypasses, and thereof. Mining area. For such period and such conditions as will be described in the rules, in addition to the user fee payable under Rule 3 of the rules. Then you can see. 81 4. In terms of a new rule as Rule 3A after the existing Rule 3 for position user fee, notwithstanding anything contained in Rule 3 of these rules, the state government may by notification in official rate in addition to the amount of user fee payable under these rules provide for a scheme for payment of composition user fee for such period and payment by all such mechanical vacuums which are liable to pay user fee for use of any state rules or part thereof or commuting in mining areas as the case may be, subject to such conditions and such restrictions as may be specified and as or as prescribed within the law. The levy of such proposition user fees shall be based on to and pro basis, and such user fees shall be such amount for 1 day, or such amount as may be specified within the law, and such amount may be revised after such interval as may be notified within the law. Any such mechanical factor liable to pay the proposition user fee under the rule, contravened in the control, then the court is deciding the proposition user fee may be based on the to and fro basis. Such user fees that will be 600 for each way. For this purpose, the base year shall be the year 2021, provided such user fee rate may be high yearly at the rate not exceeding a rate of 3% per year on every first of every each year. This will not sub A. In addition to the user fee collection, Rule 4.5, the state government may by notification implement the payment of such user fee or the proposed user fee online or offline from such mechanical vehicles or from such other commercial vehicles for the use of the state and or for transporting the minerals and or other commercial goods, and the payment of such user fee or the proposition user fee shall be mandatory for the issuance of e-challan or the challan by the authority authorized for issuance of the challan for transportation of such goods. So, we will not applicability will not how under what circumstances will the commission user fee will be imposed and how it will be realized. That is provided here. Thereafter, you have to realize page 82. Sub 3 minutes. Each activity will be defined. In terms of a new sub 3 after the existing sub 2 up to 8. Sub 3 notwithstanding anything contained in these rules. All such users carry commercial vehicles and or other commercial vehicles carry transporting goods falling under the category of commercial vehicles. The user fee and or the proposition user fee may be collected without extra toll plaza. Then next will you have to change the degree. How it will be charged that provide 83. उस संशोधन नियमावली के कार्यान्वयन की प्रणाली निम्न होगी। प्रोसीजर को प्रोवाइड किया। खान एवं भूतत्व विभाग द्वारा अनुसूचित हेतु चालान और ई चालान निर्गत करने की प्रणाली है। उस प्रणाली में खनन क्षेत्र में मिनरल कैरिंग कमर्शियल वैल्यू के यूजर फी को समाहित करने के लिए खान एवं भूतत्व विभाग के माध्यम से कार्रवाई की जाएगी। यूजर फी और प्रोपोजिशन यूजर फी राज्य के राजस्व एवं प्राप्ति क्षेत्र में सड़क के निर्माण अनुमति के विरुद्ध जमा कराने हेतु नियमानुसार सतत शीर्ष की रकम कार्रवाई की तो विभाग के माध्यम से की जाएगी। वेब पोर्टल के माध्यम से ई चालान के सृजन हेतु सूचना प्रौद्योगिकी एवं ई गवर्नेंस विभाग के माध्यम से की जाएगी। So virtually this composition user fee is nothing but will not give you services rendered. Will not the roads, bridges, etc. will not in the mining area that is being used by the mineral carrying commercial vehicles. So in use thereof the services in your services rendered. Not here that here people they people just not recognizing this. You know, the letter 17th of February 2022. These rules will call Jharkhand Private Fee Registration of Rates and Collection Amendment Rules 2022. The Rule 3A, the present rule, the amended rule is not the composition. User fee may be based on the to and fro basis. Such user fee shall be 600 for each way, except for such commercial vehicles carrying material less than 9 tons. यहाँ पर ये exclude कर दिया गया if the vehicle carrying less than 9 tons. For this purpose, the base year shall be the year 2021. Provided such user fee rate may be revised yearly at a rate not exceeding a rate of 3% per year on every first of every year. So, we not competence of the state legislature is there. We not by virtue of 50-59, these two we not state this. Secondly, we not the entire procedure has been prescribed under the rule. If you are seeing this in the entire meaning of the petition, but what is the whole argument is based on as the rule is being challenged. Silently, that is the argument. But only they are indirectly, they are challenging the very virus of the rule. So two objections that is there. Number one, the rule is there. Unless so long these rules are in your existence, the state government is empowered to collect the fee in the form of proposition. Secondly, we need to discuss WPP. My level friend has 5 minutes, but only we are discussing WPP. Now, our level friend has relied on the judgment of the Supreme. Every judgment has to be read in the context, not in the part. By taking one paragraph from here, one paragraph from there, and interpreting it one way, that will not suffice the purpose. And then, as a whole, if you not see the judgment, which has relied on to find it in Baruch 12, SEC, page 107. That was in a context law. That even from charging of fee, there must be some law. The state cannot levy even fee without authority of law. That is the crux of the matter. If you even see paragraph 22 of the judgment.
Yes, it was a
water
bill charged. Water bill charged.
Now, that market fee matter is now that is come on our head. So we will be dealing with that matter. This paragraph 22 is the case. The Supreme Court has clarified that the expression tax occurring in Article 265 does not take within its scope the expression fee because the earlier position will now, by virtue of section, these articles 265 will this article 368, 366 clause 28. It is only for the purpose that a state has power must be there vested in the state to even levy fee. It does not mean that all fee is by virtue of the tax. There is a clear distinction between the tax and the fee. Now, for the purpose of methodology of the state petition, my understanding interpreting that as all the fee is the nature of a tax. So that is not the correct interpretation by other commission. But rule 34 has been referred. Relating to taxation matter, this was being referred. Taxation matter is also has to be interpreted now. First of all, the petitioner has to pass this matter. Whether this petition is compatible or not. If it will finally get that this petition is compatible, all three matters that will come to the morning. It has got quite repercussion. This requires proper consideration by the following. But 40% so far majority is concerned, and so far the competence and the power and the provisions are provisions clear. They have not challenged, they have contemplated, they have therefore that they are contemplating to challenge it. So, but when you have the charge is leading like a source from the petition itself.
So you have not shown the notifications by which the section of the highway has been notified, in respect of which this composition user fee shall be levied. That are the two expressions used in the rule. Section of the highway where it can be levied. The entire state, all roads are not state roads. There are REO roads. State roads have a definite connotation. PMJRY road is not a state road. So that notification specifying that from Pakur to say particular so many places are there. 80.
State roads. For the purposes of these rules, mean the state highway, roads and all bridges, including interchanges, flyovers, RUB, bypasses, tunnels, and constructed through any state public funded project or deposit work, and includes all such roads falling within any mining area thereof, but excluding the national highways and or bridges, interchanges, and conclude through any central government project. So all projects funded by the state government, that is included in the term state roads.
No, that is there, but the collection will start as per sub-rule 2 only from a date to be notified from the date of completion of the section of the state road. All states roads are not in completed stage. Some are under construction. You can charge a composition user fee as per the scheme of the rule from a road which is complete and the user is using it. And the fee is being taken to repair it because of the damage, to repair the damage which may be caused because of the use by the user. So, sub rule 2 of the same amended rule 3 then becomes OTOs, no purpose. Page 81, at the third sub rule 2, third sub para from top.
Coming to the question of user fee as David under sub rule 1 of rule 3, that coming from first date as it is specified notification is draft from the date of completion of this section of this statement. So this is a special argument. I will require to see the section of this. But so far we have the very first reason is not that the first of all the directly has to be decided.
No, that we are concerned. That we are
We go into the merits of the case. It will also not be our own so far the merits of the case is concerned, and these are the special arguments which will be special and response. But as I know, I am able to show you the wrong thing. That rule is there, competence is there, and not the rule is workable. So, without the levy of not this fee, that is as per the rule.
नेचर यही है कि ये फी है, फी होने के चलते फिर एलिमेंट है आप कीजिएगा तो रिपेयर आप लिखने में रिपेयर होगा तब फिर टेक्नोलॉजी की जैसे म्यूनसिपल कॉर्पोरेशन वाला इस तरह का फी होता है वो रोड को साफ कराता है ये कराता है लाइट्स होता है लाइट आपकी से लेने से थोड़ी कि आपके घर वाला लाइट जले बाकी तो इसीलिए जब बैकिंग से दोनों इम्पोर्ट आपको अपने कन्वीनियंस के लिए टैक्स कन्वर्ट को उसको डिवीजन बेंच में रखता है उसका लार्जर कम्युनिकेशन फ्री सेग्रीगेटेड टाइप का ये शुरू में इसका कम्युनिकेशन है इससे फ्री है इसका कम्युनिकेशन भी टैक्स
Mr. Jodia, on the point of maintainability, prima facie, we feel that for the effective functioning of the court, a nomenclature has been defined. It is not that, as per the larger definition of tax which you have shown, fee doesn't need to have backing of statute or a statutory backing to levy it. But for the effective functioning or the business, efficacious functioning of the business of the court, matters which are per se tax are being listed before the division bench and rest of it go before the single bench. Now, by the nomenclature of this expression itself, it is fee. Therefore, the stamp reporter, took a literal view of the matter and, of course, without any such interpretation attached before a stamp reporter, he said that it is. The other fallout of which we consider it more grievous or serious is that then all kinds of fee will start coming to the division bench. Not only that, the petitioners will also be denied intra-court appeal. Intra-court appeal.
Yes, we are conscious of that, but if you are also to see what the fee which is being levied, all kinds of fees are very few of them. it's a matter that somebody has not seen whether it is an impose, because the word used under rule sub-rule 2 was conscious is the word taxation. Because the term taxation, when it is used by your lordship in the High Court rules, cannot be bereft of the definition of taxation under the Constitution of India. It was deliberately used, the word taxation was deliberately used, my lord, in the rule which I have said. To bring it, the taxation here is not only confined to what we understand as tax, because taxation has to be understood in the context of tax and impose. That is where your lordship had used the word taxation instead. If it would have been only used as tax also, my lord, sub-rule 2, then my lord, the interpretation could have been with respect to that whether we go to the definition of sub-clause 28 for the purposes of interpreting which matter would lie before the division. But the word deliberately used is taxation, which is defined in the Constitution of India, and which includes an impose in the exercise of the sovereign powers of the state.
No, but then you have not included in your compilation the line of decisions where the distinction between a fee and a tax have been explained.
Also it has been made, but fee, tax also distinctions
No, no.
are there.
The
But those lines of decisions that I cited earlier also, but where it says that the fee is basically a quid pro quo for the benefits which are to be given, and taxation is a compulsory levy.
it actually started with that kind of a concept. The first judgment was, I think, of 1957 Constitution Bench. The name of the party was some, if I'm not correctly remembering, some South Indian kind of a name. Very famous in all fee matters. If you will find out, the first judgment is of that 1957. Tirthalankar, something like that. In that, the distinction between tax and fee was expatiated. So that evolution of the understanding of a fee gradually got diluted over a period of time, but the element of quid pro quo was not left out. The understanding grew in the sense that it may not purely be a quid pro quo, but if the benefit of that fee is also extended to the general public, like there are many municipal fees and fees of like that, then also it will retain the character of a fee. In fact, I had researched all that in that.
Yes, it will not be a direct and immediate effect, but it is some benefits which are being extended also, then it will fall within the category.
So that those line of decisions definitely make a distinction between tax and a fee.
Yes.
If we go on that distinction deeply, then the nomenclature which has been framed in the High Court would appear to be justified, because tax matters which actually are proper taxation matters should be heard by a division bench, and those in the nature of a fee should be heard by the single bench. Taxation coming straight away, of course, from the backing of law, but meant to be levied over the public at large. Here it's a specified section, in fact.
Here it's a specified section, in fact, but even otherwise, you have to take it in the purpose for which that taxation matters have been included. So it has a backing of law, of the Toll Act and read with the rules, and the specific section itself, which is there, which provides for levy of this kind of imposed by way of a sovereign function. So I don't say, Madam, that each and every fee, your lordships may declare that each and every fee matter would come before the court. But where the fee is being levied in the nature of a specific sovereign impost, by virtue of a statutory backing and corresponding rules thereunder, that definitely will subject your lordships ultimate to.
No, because it has a wider repercussion or a consequence over the entire functioning and working of the court. So many matters would naturally come out from the nomenclature of WPC if we hold in your favor as you have done. If you insist on that, then we will deliberate and pass a proper detailed judgment. But if you want your remedy to be more efficacious concerning the pressure upon you, You can agitate it before the learned single judge as per WPC nomenclature.
Then we are only subject to lordship and pleasure, prima facie, but we go with the pleasure because your lordship have to administer the high court and lot of things come in your lordship's mind. Then, if your lordship, otherwise I have a forum before your lordship again with respect to that. So your lordship may take and permit me to convert it into WPC. And we're looking into the urgency, but if your lordship may just give us a liberty to mention, because otherwise,
No, we will ask the registry to list it tomorrow. It may not be possible because some office, first opening day after Holi it can be listed.
Only our concern is my friend is appearing and he is a responsible government advocate. At least this 1 week they may not perpetuate it, they have started perpetuating it immediately after all these writs have been served upon them. All the lessees, other than these lessees,
they have also come to know the lacunae that you have pointed out.
Yes.
So if they really deem it,
they will not be able to do that. One judgment of your lordship on the division bench, Justice Patel. But software is to facilitate the
the notifications.
Correct. So, even that notification, the GIMS portal, how will they, what they simply did on each and every transaction page. But they can't have a notification of a general nature that each state road is notified here, irrespective of the completion. So that is where 1 week only, if your lordship may just, my friend may only say that till the next date they may not perpetuate the matter.
Lordship will appreciate your difficulty, revenue matters for at least from our side. My letter is pretty lot to say anything.
No, but the other side of it is that the business will stop. No?
Yes, exactly.
They will stop. They will stop transporting minerals for a week or 10 days.
I don't think
there are letters. 2 days time is given. Otherwise, the profit is there.
At a departmental head level, you can deliberate over it so that things are not precipitated.
No, I can call to them, but I cannot give you later.
And even otherwise, we are generating the answer showing as due. Ultimate result of the writ petition would.
So, any action will be subject to outcome that is there. You will be in the process not observed. So, any action will be subject to outcome. And we are agreeing not that this matter will be outcome.
So you convert it then. We will ask the registry.
The liberty to convert it and 21st, 22nd.
So we will not say anything about the arguments.
And we understand that. Otherwise, it was a fit case for a WPT.
My letter friend says, definitely go to the city, then I will give you my cousin.
For any state, even if I am depriving
I will give you my cousin.
It's an urgent matter.
question of maintainability of so far as the defect pointed out by the registry as to the correct nomenclature of these writ petition and its maintainability before division bench as WPT is concerned, comma, since the impost is in the nature of a composition user fee, which would ordinarily lie as per the High Court rules before the learned single bench, learned counsel for the petitioner undertakes to seeks permission to convert the writ petitions as WPC from WPT. Stop. Then counsel for the petitioner submits that permission may be allowed to convert the nomenclature during course of the day since there is an urgency in the matter. Stop. Then counsel for the petitioner submits that the department is likely to take coercive steps for realization of the composition user fee through the GIMS portal being levied through challan by the GIMS portal, though certain provisions of the stop. It is submitted that besides other grounds which the petitioners have raised, the requisite notifications in terms of Rule 3A and Rule 3A 3.2, Rule 3.2 and 3A1 have not yet been notified. Stop. Which page was that rule?
Page 81, violation is page 129.
129.
Relevant is at page 131.
Rule 3.2 and
3A1.
3A1 have not been issued. Stop. Then counsel for the petitioner is permitted to make necessary to carry out the conversion in the nomenclature of these writ petitions during course of the day. Stop. Registry may list the matter before the appropriate single bench, if possible tomorrow, or otherwise on the reopening day after Holy Days. Mr. Yadav, your officers are standing on the back for what? Ask them to take a seat. Ask them to take a seat.
for admission. Item 12, WPS number 6744 of 2018. Mr. Ruby Pandey for the petitioner. Mr. Gautam Rakesh, Mr. D.K. Chakravarti for the respondent.
लिस्ट चला गया ना. Yes. Not able to for withdrawal.
The subsistence allowance will not be
All I think for withdrawal. So this one, what do you want to do? Because there is a petition already pending. No, you are Miss Mohini Gupta. So you are counsel on record or not? Who else is? Senior counsel is not a
Ruby Pandey.
She is not there. So your petitioner wants to pursue this writ petition besides the previous writ petition which he has filed for the same relief, or he wants to withdraw. And no, the lordship will only punish him if he chooses to continue with a second writ petition concealing facts. So that is what we are waiting to hear from you. Otherwise, we will have to ask him and issue notice upon him. वही तो last date it was adjourned for the said purpose. But before we proceed, petitioner, if he has wisdom, he can withdraw the matter.
तो दूसरा what effective to 2020 लिखा हुआ
During penance. Yes, Ms. Ruby, क्या कह रही हैं? इसमें तो there is no point in arguing.
just withdraw it.
फिर आप उसकी बात क्यों कर रहे हैं? उसका तो एक रिट पिटीशन आपने पहले ही फाइल करके रखा है. इसको क्या करना है? बोलिए. पर आप न करेंगी, हम आप बोल ही नहीं रही हैं. Then counsel for the petitioner, Ms. Ruby Pandey, seeks permission to withdraw this writ application. So it is submitted that the petitioner has sought apology for filing the present writ petition that was filed from different office and had inadvertently, as he had inadvertently not informed the learned counsel about another writ petition, service number 7258 of 2016, which was preferred for the, which was preferred for the same relief and is still pending. Stop. In view of the submission made by learned counsel for the petitioner, the instant writ petition is dismissed as withdrawn. लिस्ट नहीं मिला.
Item 13, WPT number 2018 of 2020, along with item number 14, 15, 16, and 17.
There are three orders in this matter where the hospital notice that on earlier time at
The adjournment request is from your side.
here in Delhi because of you are there, to go to Canada.
You are there, so a battery of state councils are there on the panel. Last week also, some matter got adjourned because Learned Rajiv Ranjan Senior Council was not present.
Because some reason I
You see, all the central authorities have their specified lawyers to do tax matters. Why can't that arrangement be made in the High Court also?
So we are also able to
No, you have a battery of lawyers. You see, in the previous matter of that confusion fee, 3 state councils were there.
There is a problem also in that. Some brief has been allotted to you, some brief has been allotted to Mr. X, Mr. Y. So,
Counter affidavit filed at different points of time. Who will argue? Who will assist? No, what we are saying is something different. For income tax, earlier brother was there, now somebody else is there. For CGST, someone else is there. For service tax, someone else is there. So there is a nominated counsel who knows about the entire tax law relating to that subject. Here you are also there, Mr. Yadav is also there, Mr. Pati is also there, Mr. Sabu is also there. So tax is a very intricate matter, na? This kind of a specified tax council for the state government, that would be useful for your own house also.
So we are also problem here because
No, that may be there. Mr. Goroya had been mentioning it for quite some time because some senior counsel. And we also accommodate as per our own diary and convenience. No? So. And on 21st, next Monday, the item 13 to 17, Learned Counsel for the State AG2, Learned AG2. Mr. Sachin Kumar has prayed for an adjournment on the ground of Learned Advocate General, who will argue this case. Stop. The matter has been listed today at the instance of Learned Counsel for the petitioner after consent being taken from the State Council. However, for the reasons stated above, as prayed for by Learned Counsel for the parties, this is the case on 21st. No, you are also agreeable for the 21st. And
agreeable, but adjournment Baroda.
नहीं वो तो शुरू में लिखा था, वो तो है शुरू में ही.
In the beginning, I have indicated that it
Yes.
was at his, but the next date is
Next date is.
as prayed for by Learned Council for the parties list the case on 21st March 2000.
And not only indicated, what is indicated earlier in one order, that they will not seek any further adjournment. That will be indicated. Otherwise, but I do respect for the learned advocate general may have put other applications. But equally, Marot, this is leave it to Marot and he has to.
So he should remember that he will not take any adjournment next time.
We will take. Now, thank you, Lord. The persons who are not expert, Lord, can also do better. Lord, and
You are expert.
I have a real going back better, also better.
Yes. So in 2021 also there is an adjournment.
Yes.
From whose side? Appellant.
Yes, in 1920, the move and adjustments on behalf of the
In this case only some counsel from Delhi was, I saw file there, file there item 2021.
2020.
Rajiv Srivastav was appearing.
There are two appeals, one by us and one by the state.
So who is praying for adjournment?
I am praying for adjournment.
No, which appeal?
It is first appeal of 7 of 2021.
The senior, we have immediate senior Lordship, he has come to the Lordship.
He has?
He's here, the Lordship. Senior is here.
Where?
Mr. Rajesh Jharkhand is just coming to the Lordship.
So, that is what I was mentioning, that last date it was fixed for today on his request.
The last appeal
Today the appellant's counsel is asking for adjournment. This adjournment system should now come. It was very practicable in the virtual courts, but now we won't grant adjournment. List meaning.
Lordship is just coming, Lordship.
Yes, Mr. Rajiv, your other side is today asking for an adjournment.
Lord, only one submission I would like to make, Lord, if your Lordship permit. Lord, what if my child has been instructed by the client that when the respondents in the writ petition, they were promoted, even at that time, the number of posts were available for the petitioners, and even today, there are about 90 posts which is vacant. So if the order passed by Honorable Single Judge is implemented, even then, the petitioners, the intervener, because now the petitioner, even according to the application of circular, as it has been applied by the government.
No, but the appellant state is agreed by the interpretation of that circular itself. Na? They don't want to accommodate people left and right, even though there might be vacancies.
No, but that aspect may also be examined by the state and.
That circular of 2014 applies to all departments equally, and if this interpretation is extended, then there will be a administrative chaos in their different departments. That is their concern. So we will hear it on merits. Now some interim arrangement may not resolve the issue. So then let it come after 2 weeks on any day.
Except 6th of March.
11th March, 11th April. 11th April.
11, 12 and 13. Then it will be not after that. 18 to 20. Would it be on 18th or 19th? 18th or would it be on 20th of April?
18th April.
Or on 20th virtual day?
We do not know whether the virtual day would remain or every day would become virtual by that time.
Not 18th?
18th is fine.
18th.
There is a request for adjournment on behalf of the appellant by Mr. Chanchal Jain. Stop. An email to that effect was also circulated to other parties. Stop. Therefore, the matter is adjourned on the request of the parties to adjourned and posted on the request of the parties to 18th April 2022. ये 26 को जरा 1 मिनट कॉल करो.
Item 26, WPT number 985 of 2022, Mr. Nitin Kumar Prasad, for the petitioner, Mr. Rahul Saru.
Mr. Kurmi, I was unable to recognize you because of the mask, but really good to see you in person.
In person.
Today. So,
In this case, what's it?
this is also the same kind of matter which we are going to deliver the order today for us. Right?
Yes, forward.
Yes.
Almost same.
In that issue also, the TRC 01A was issued earlier. Thereafter, the order was passed.
Order was passed. No show cause. No show cause.
In this case also, TRC 01 issue,
Yes.
straight away order is passed. And
No show cause.
some of the orders are uploaded. That is the case, and garnishing proceeding is initiated now. That reference is done.
Who is for the?
को समझना चाहिए आप डिजिटल कर दीजिए देखेंगे तो बाकी किसको क्योंकि एक टैक्स पढ़ने तो आके आपको टिप पे आ जाएगा बहुत लेस देन 100 तब जाके आप इस फोटो पे लोग से इसको बहुत सारे कोई दिक्कत नहीं
Now let us see page 94. Next up is page 94.
That is DRC 01.
01 and if you also see below that box,
Yes.
You are given advice to pay the amount of tax and the second amount along with the amount of particular interest in full by this day, wherein which proper notice will be issued under
Same way, sir.
So I am trying to say the order. The
Have
order
you,
also says.
have you sent a word to Mr. Rahul
Yes,
Sabu?
yes.
Yes.
Now the page of order is on page 20.
Hmm. Page number 120, annexure 5.
1201, that's the 5. This is the order now, which is part of super notice. Just last table of that anticipated.
Yes.
Last table of that.
Hmm.
लेखक सूचना के अनुपालन में करने व्यक्ति के अधिकृत अधिवक्ता श्री शोरसो दिनांक 1/20 को उपस्थित हुए एवं उसके द्वारा अपना जवाब प्रस्तुत किया गया। करते व्यक्ति द्वारा प्रस्तुत कागजात सुविधाजनक एवं तर्कसंगत नहीं पाए जाने के कारण 8201 एंड 2 दिनांक 1/9/2021 को रिजल्ट किया गया। तो अनडिस्प्यूटेडली व्हाट द इशू इज समरी 8201 is summary of super notice and DRC 02 is summary of the statement. Now 71 says super notice are issued. In particular here, assuming that the issues are same, or even I would like issues are there, and super notice are the issue. Putting the entire operations and legislations, setting out everything, and the subsequent super notice on self-same issue or subsequent period. There is no requirement of issuing a detailed super notice. As you also held, in the case of first super notice, when you come to second super notice, the ratio will not apply. Because in that case, if the grounds are same, only statements required to be. Because the charge of ground is same. So what is happening? DRC 01 is summary of 731 super and DRC 02 is summary of the statement. What they have done, they have mixed up the two things. They have issued DRC 01 assuming it to be super notice and issued DRC 02 assuming it to be summary of the DRC 02. This is what they are understanding in the department, what I have seen.
Where is that DRC 01 and 02?
Now it was not sent to me. I did not receive it. I did not receive super notice.
Have you stated that?
I have said no. DRC 01 is not sent on me. DRC 02 is not sent on me. Super notice they are also they are saying they have issued DRC 01. But they are saying that. So in my case,
Where have you stated that DRC 01, 02 was not served?
Page 12, page 16, page 16.
And about DRC 02?
02, they are saying, but it is not required here. My case is not found as 02.
You have not been given any other statement for the same period. So 01 is the only one, and the show cause notice, proper show cause notice, in terms of that NCAS. So, Mr. Sabu, are you prepared with it?
I have gone with it, but we are presently still under section 73, subsection 1 has to be not given that I have to be
No, you have to file a counter appeal.
Yes, I have to file a counter appeal.
You see, because of this lacuna in the proceeding, all matters are coming to the High Court instead of going before the appellate.
Yes, I have seen your judgment.
So,
if it is statement of certain line or such, I would need an interest.
So what you do, your client may do, Mr. Kurmi, is to keep the amount indicated in the garnishee notice intact in that account. And in that case, the respondents would not take any coercive steps. This would balance.
For me, because ultimately, my lord, there is no so-called notice there. The order itself says.
No, the order says DRC 01, and you are taking a plea that DRC 01 was also not served.
Yes.
So we need to ascertain on facts whether.
Assuming that they have served DRC 01 only, undisputably, so-called notice is not served only. As going by the order, so-called notice is not there. So I am directly covered by the executive. And one market from the judgments, the judgment will not say, market was closed.
You seek instruction within a short time.
Yes,
We can keep it on 22nd.
My lord, this 23rd minutes.
He's coming from outside insufficient. 23rd will suit you perhaps.
22nd, let it be on 22nd.
Schedule काफी fixed है. On 23rd there are several matters.
Let it be on 22nd. This one. RK Transport.
Well, section 9 can be invoked for partnership. You ask for one paper. Under what circumstances the partnership can be initiated? You ask the head, that is another court has also accepted the second issue, but the recovery proceeding under section 79 of the GST Act can be initiated for recovery of interest in that case for interest. Under section 15 of that without initiation and completion of a proceeding under the Act and part 22 of judgment which is quoted here under 22. The next issue for identification of interest application is as to whether the partnership proceeding under section 79 of the GST Act can be initiated for recovery of interest without attributing the liability of interest when the same is admitted disputed by legislation. Section 79 of the CGST Act empowers the authorities to initiate partnership proceeding for recovery of tax where any amount payable by the person, the government, and any of the Act and whose pay they are under is not paid. Since in the preceding paragraph of the judgment, we have already held that though the liability is of interest for public, but the same is required to be adjudicated in the event an FSC disputes the computation or very liability of interest by initiation of judicial proceeding under section 73 or 74 of CGST Act. In our opinion, this such adjudication is completed by the court official. The amount of interest cannot be termed as an amount payable under the Act of use, but without initiation of any judicial proceeding, no recovery proceeding under section 9 of that can be initiated for recovery of the interest amount. And also that has come to bear again. We are of the considered opinion that the case of present petitioner stands covered by the issue rendered by this court in the case of Maharashtra Construction also, and despite disputing the liability towards interest, the revenue has raised a demand for payment of interest on the ground of delay of noticing GST of 3 year term for the period July 17 to without initiating any executive proceeding under section 73 or 74 GST Act. Earlier by an order dated so and so, a court had said this court had wished to grant interim protection from any person is placed against the petitioner pursuant to the interim demand yet accepted. In this case, my lord, a issued me of prosecutor return is issued me recently dead and this is not paid 73.
Yes.
I issued that application at page 25.
In part B.
Part 12. Then they shall issue DRC 01A. The issue 1. And 500 at student. Page 95. In the issue order is considering that I am animal and I am disputing. So the point is that in liability is disputed liability. There is no super notice. So no proceeding under 73. So there is no amount given under 79. So no proceeding under 73.
Yes.
My lord, I will highly response not in shortest possible time. I not be to do the e-filing of the.
They don't realize.
Don't realize till next week.
I will give it that not amount.
You are not following the procedure in not this case, in numerous of cases. I came across not less than 50 cases, 60 cases जो भी है.
Because I will file the response.
Till now, that
The second one will matter.
Land counsel for the petitioner, Mr. Karthik Kurmi, submits that upon scrutiny of the petitioner's return for the period April 18 to March 19, certain discrepancy / mismatch were noticed in Form GST ASMT 10 on by reference number 5104 dated 11 February 2021, Annexure 1. Stop. Petitioner furnished a reply in Form GST ASMT 11 on 16th March 2021. Annexure 2. Inter alia, taking a number of pleas through the annexed reply. However, a summary of show cause notice was issued in Form GST DRC 01A. Sorry. This is not a statement, intimation. An intimation of tax payable under section 73 within bracket 5/74 bracket 5 was issued in Form GST DRC 01A, Annexure 3, dated 3rd April 2021, indicating the total amount of tax, interest under Section 50 of the JGST Act and penalty at the rate of 10%, amounting to rupees 3 crores 84 lakhs 11,318.04, asking the petitioner to pay the same by 19th April 2021, failing which show cause would be issued under Section 73(1) of the Act by the State Tax Officer, issued by the State Tax Officer. Petitioner duly replied to the communication in Part B of the Form DRC 01A in terms of Rule 142 within bracket 2 capital A on 13th April 2021. Taking a plea that it was only pursuant to the amendment in Rule 61(5) that GSTR 3B became a return for the first time within the meaning of Section 39 of the JGST Act and the provisions of Section 16(4) with effect from 1st January 2021. Therefore, the allegations and interpretation of Section 16(4) of the JGST Act and the purported denial of ITC of rupees 2 crores 66 lakhs 26,906 is based on a misconception of law. The noticee cannot be denied the right to avail ITC under Section 61 of the Act on any technical or venial breaches. It is submitted that under Section 16(4) of the Act, a registered person shall not be entitled to take ITC in respect of any invoice or debit note for supply of goods or services or both after the due date of furnishing of the return under Section 39 for the month of September following the end of the financial year to which such invoice or the date of invoice relating to such debit note pertains, or the date of furnishing of the relevant annual return, whichever is earlier. Stop. Petitioner also cited a number of judgments in his support. In respect of the levy of the interest, a plea was taken that no rules have been prescribed for computation thereof, in the absence of which it is unworkable. Stop. A specific plea was taken that levy of interest would start only after adjudication of the demand, as the noticee has disputed the liability. Stop. Further, penalty under section 73(8)(9) sub para would be attracted only after the demand is adjudicated upon proper show cause notice under section 73(1) of the Act and is not paid within 30 days of issuance thereof. Stop. It is the specific case of the petitioner that no show cause notice under section 73(1) was issued after the intimation under DRC 01A. Such a statement, categorical statement, has been made at paragraph
16.
16 of the writ petition. However, the adjudicating authority has proceeded to levy tax, interest and penalty by passing an adjudication order on 1st November 2021, Annexure 5, to the tune of rupees 3,84,11,318.04 and directed for issuance of the summary of the show cause notice under DRC 07. So this time the order, adjudication order, has been communicated.
Was uploaded.
Okay.
Uploaded.
Stop. Then counsel for the petitioner submits that the procedure that the adjudication order is vitiated on non-compliance of the principles of natural justice and on failure to follow the procedure prescribed under section 73 of the Act. Stop. In this regard, he has placed reliance on the case of Messrs. Encas Private Limited versus State of Jharkhand, reported in 2022 VIL 139 JHR, and also on the recent decision of this court in the case of Arcade Transport Private Limited versus the Union of India, reported in 2022 within bracket 2 TMI 1051. What is this TMI?
That's fine with me.
Tax management. Stop. It is pointed out that the department has further proceeded to issue garnishee notice in form GST DRC-13 upon the petitioner's bank, petitioner's Punjab National Bank, asking it to debit an amount of rupees 3, debit or hold, whatever, to pay the sum of rupees 3 crore 84 lakhs 2528 to the government forthwith. In terms of section 79(1)(c) of the Act, making it clear that failure to do so shall render the bank to be a defaulter in respect of the amount specified in the notice and face consequences as per the Act and the rules. Stop. Then counsel for the petitioner submits that there is no
Yes, I know. Last but not least.
yes, that the counsel for the petitioner has relied upon the judgment of a coordinate bench of this court, of which one of us, within bracket Deepak Roshan J, was a member. Mahadev Construction. Company versus Union of India and others, WPT number 3517 of 2019. Judgment dated 21st April 2020. Stop. He submits that this court has held that in the event the SSC disputes the leviability of interest, no recovery proceeding under section 79 of the Act can be initiated for recovery of the interest amount without any adjudication, initiation of any adjudication proceedings. Stop. This is the perusal of the adjudication order dated 1st November 2021 would itself show that no show cause notice under section 73(1) summary was also not issued,
Summary was issued.
or any summary.
Summary. They are telling you. I am telling you not summary.
Oh. And no summary, no show cause notice under section 73(1) of the Act was issued, and petitioner denies issuance of any summary of show cause notice either. Stop. It submitted that in those circumstances, the respondents may be restrained from taking any coercive steps for realizing the amount in question through the garnishee notice from the petitioner's bank, Punjab National Bank. Then counsel for the respondent state seeks short time to file counter affidavit. When? As prayed for by Mr. Rahul Sabu, Learned Standing Counsel 1. This the matter on 22nd March 2022. Counter affidavit, if any, be filed by 21st March 2022. If any, be filed by 21st March 2022. Stop. In the meantime, no coercive steps be taken against the petitioner pursuant to the garnishee notice in Form GST at Annexure 7, dated 1st November,
No, like 25 to
25th February 2020.
ये तो आइए कहीं
हाँ। IA number so and so seeking stay of the proceedings stands disposed of.
Item number 134. Item 1. Last case.
अच्छा, कॉल करिए.
Asobat case for order to defect item 1, WPT number 798 of 2022, Mr. Nitin Kumar Pasari for the petition, Mr. Amit Kumar for the response.
You have removed the defects. Then counsel for the petitioner is permitted to remove the surviving defects during course of the day, sir. That time also we had indicated. No? That time also we had. Yes, so Mr. Pati, the very short point here, perhaps you might have gone, that his appeal is pending, dismissed for default, there was a prior stay on pre-deposit and restoration application is pending, but tribunal is not functional because there is... No, now the tribunal is not functional
Now only single bench.
because the single bench is.
Yes. Because my appeal was dismissed for default by the division bench.
But otherwise, since 2017, when the registration was papered in long back in the year 2017 and para 16. 5 years, madam, there is no feeling that during all this period the tribunal was non-functional.
No, so once the recovery notice has been issued, then they have rushed.
Para 16 I don't see. Because in fact, para 14 was not very relevant. He comes to know in 2016. Takes steps in 2017. Even from the date of filing of the restoration application, now it is around more than 5 years. Para 16 After filing of the restoration application, the same was registered as a restoration number.
Then you seek instruction.
Fine.
Then counsel for the petitioner submits that surviving, petitioner was that a stay was operating. Where is that order?
That order came not ready.
No.
The pre-deposit receipts we have, in that is mentioned 1/7/2015. Which I just passed.
No, in statement, where is that?
In which paragraph you used?
We have not mentioned it.
It is not there.
When you seek instruction,
Seek instruction.
And if you file a supplementary application,
you file it, and then counsel for the, this is CGST or service tax?
No service tax.
Then counsel for the
now it is CDST.
CGST, Mr. P.S. Pati, grace for allowed 2 weeks time to obtain instruction and file counter affidavit. This is the case on April 6th. Petitioner may also file reply if so advised within this time.
One line is managed to indicate that pre-deposit of 10% has been made, that is an admitted provision. I have the receipt, I have given a copy to my relative. It will make some difference, it will make some difference. Whereas I just,
Because that also is not on record, no?
I have it in my hand.
So give it to him,
I have given it to him.
then it will serve the purpose.
It's definitely indicated that.
You give it to him through a supplementary affidavit, then he will have all the more reasons to. Give it by way of supplementary affidavit, and file it. That order they are not able to procure, no? The kind of petitioner,
Statement to that effect, giving the
The petitioner,
Petitioner is
we have seen the petitioner. Yes. Yes, let us take remaining matter.
Item number 18, WPT number 3908 of 2020, along with item number 19. Mr. Sumit Golia.
Tell your officers to come. Yes. Mr. Yadav, have you seen their reports?
There is no manipulation.
No, manipulation का बात नहीं है. The order sheet, does it reflect that the adjudication order was passed on 13th August? भाई हम लोग को don't confuse us. जो क्वेश्चन पूछे उसका आंसर सही सही कम से कम दीजिए. 13 अगस्त 2021 को वो ऑर्डर पास हुआ था, वो ऑर्डर शीट में रेफर किया. That's the end of the matter. If they take it out from anywhere, cupboard, wardrobe, wherever, drawer. ठीक है, तो the proceeding suffers. Proceeding suffers. Proceeding suffers. 14th of
13th is the final order, 14th is your date sheet in the order sheet.
14th is the date sheet in the order sheet, but there is no mention about separate order passed on 30th.
13th को पास कैसे कर दिए? कुछ करते हैं तो डेट ध्यान में दिया कीजिए ना.
74/9 में separate order passed.
What is his good name? अच्छा, he is retired now.
13 को मैंने ऑर्डर पास किया. इन कंसीक्वेंस ऑफ पासिंग ऑर्डर लेटर ऑफ नेक्स्ट डे डिमांड was
13th के ऑर्डर का 14th के ऑर्डर में भी कोई रेफरेंस नहीं.
हां, ये रेफरेंस देना भूल गया.
So there is a clear admission to proceed against this person. You are so sanguine about proceeding against the SSCs, proceed against your own officer also. Is it not a misconduct in the performance of duty? What does your commissioner has to say? The order was communicated to the commissioner also. Have you got an instruction from the commissioner?
From commissioner side, from instruction to the order and communication.
So today when you appear, you should have got the briefing from your commissioner also as to how this is a matter relating to tax administration in the state, na? And every day, every matter you are saying we are facing the same problem. And in no CGST matter this is happening. I mean, central authority.
But I was in the morning I had formulated this only, but central authority But we have not come against any of the adjudication proceedings from training violations or otherwise.
In almost 70% of cases, procedural lapses are there.
What impression does a neutral body take? That it may be to help the other side? Proceeding in accordance with law is bound to suffer if challenged. So now tell us, all kinds of excuses, will it rectify the um, patent error, manifest error in the proceedings?
Three errors.
What patent errors? That we have indicated in last order.
Opportunity of personal hearing or patent error. Statutory opportunity and of course the order I have not taken.
Mr. Pati, you are for CGST in this. See, central authorities are not committing this kind of mistake. That without any order in the order sheet, the order is passed in a separate sheet and kept in a drawer, and suddenly, while serving DRC 07, also the date of the order is something else. What more grave and grievous do they expect us to be confronted with?
That may be a human error because otherwise we have seen cases where it is time marked then it is done. Those cases we got an assessment. Cases where the proceedings become otherwise time marked and there and we get at times my lord.
No, ordinarily, on the date on which the adjudication order is passed, a consequential direction is issued to issue DRC 07.
And in the file also a notice made that separate order alag se isme pass kiya hai. That is there that we have seen in the
प्रीवियस डे में कैसे होगा? पोस्ट डेट में हम इनएडवर्टेंस मान सकते हैं कि 13 अप्रैल जो भी डेट है दैट ऑन दैट डे ये डायरेक्शन हुआ 01 इशू, उसके प्रीवियस डेट में कैसे होगा? बाद में हो सकता है जिसका रेफरेंस नहीं दिया हुआ है. फॉर्मल ऑर्डर शुड बी इशूड in this line.
In fact, I have annexed certified copy. Certified copy application I have annexed. The entire certified copy application for this purpose. It was a specific plea that there is no adjudication order passed. Your lordship to see the counter affidavit. The adjudication order which has been annexed does not even spell that this is what the adjudication order has been passed. There is no mention as to there annexing that adjudication order without any statement in the counter to that. Just an action being made in one silence. Some officers are there but who have
One thing, Mr. Yadav, whether you yourself will correct the discrepancy by issuing show cause notice to the petitioner or you want an order. If the order will flow, then certainly same type of order is being passed in every cases, something more will be there with regard to cost, etc. So either you yourself will suo motu, after accepting the discrepancy in this case, issue a show cause notice or
withdraw the order.
Withdraw the order or issue fresh show cause notice, or we have to pass the order.
Time limit is there.
So time limit will also have to pause it for them.
Automatic.
They will get the benefit. Otherwise, once then he has retired. Second, he only has the power of rectification which is the limited powers. It's a grave illegality which has gone to the root of the matter. But in fact, I have one of the senior officers who is really conversant with the matter, Mr. Kapasa. I don't know if you know there's a lot of matters in the safety commission. It is only he was not aware. I don't think he would be aware as to what has happened. And he is one of the most upfront persons who has been doing the matters in the department.
Respondent number 3 is also there.
Yes. Yes.
Who is he?
He is the person who has issued GRC 01A.
आगे आइए, आगे आइए। नहीं, डिप्टी कमिश्नर कौन है?
अभी प्रेजेंट डिप्टी कमिश्नर।
अच्छा, आप किस पद पे हैं?
असिस्टेंट कमिश्नर इन दैट सर्किल और ये वो तक कार्रवाई सर मेरे द्वारा की DRC 1 तक मेजर करने की कार्रवाई मेरे द्वारा की गई। उसके बाद हम रिटायर कर गए थे सर। उसके बाद प्रोसीडिंग DRC 1 डिप्टी कमिश्नर साहब के सर ये पूरे प्रोसीडिंग को देखा जाए तो हम कुछ कहना चाहेंगे सर, क्योंकि पूरे प्रोसीडिंग में DRC 1 के पहले इनके द्वारा कई बार टाइम दिया गया था रजिस्टर को लेकर, इनके द्वारा एक बार कुछ रिकॉर्ड किया गया, उसके बाद कोई भी रिकॉर्ड।
ठीक है, वो आपको बताने की जरूरत नहीं है क्योंकि लॉ जो है ना वो ऑलरेडी वेल सेटल्ड हो गया है। DRC 01 के बाद क्या करना है, इंटीमेशन के बाद वो सब सेटल्ड आपके नोटिस में ही लिखा रहता है कि नहीं पे करिएगा तो 73(1) का नोटिस देंगे।
DRC 1 ने दिया है, हम समय ऑर्डर पास किया गया था, ऑर्डर को अपलोड किया और उसी में फाइल को केवल रिप्लाई करना है, रिप्लाई करना।
नहीं, वो आपके ठीक है, वी हैव अंडरस्टूड। डिप्टी कमिश्नर कौन है? आपके बनाए हुए प्रोसीजर से नहीं चलेगा ना, जो कानून में लॉ बनाया है पार्लियामेंट स्टेट लेजिस्लेचर वही चलेगा। आपका क्या रोल था इसमें?
पहले तो ये केस आया तो मैंने असिस्टेंट कमिश्नर नोटिस किया था। 31 जनवरी 1920 को ये रिटायर किए। रिटायर करने के बाद ये फाइनली मेरे पास आया, तो इसको मैंने सिर्फ एक नोटिस किया DRC 1 और DRC 1 करने के बाद अगेन इसको मैंने दूसरे असिस्टेंट कमिश्नर को नोटिस दिया था जो पहले भी DRC 7 है।
तो इस बीच में कोई DRC 01 यही ना है, समरी ऑफ शो। नहीं, 01A is the summary of show cause notice.
So 1 is the summary of show cause.
अच्छा, 1 is the summary.
1 is the intimation.
Intimation.
It is that we did not respond.
And no proper show cause notice was issued.
DRC 01A के साथ
और एक के साथ चूंकि डिटेल नोटिस दिया गया था, उसका कोई रिप्लाई नहीं आया था, तो वन के समय ये लगा था कि फिर से हमको एप्लीकेशन करने वाली
I have not understood the law at all.
वन DRC 1 उसका रेफरेंस दिया गया था उस पहले वाले सुपर
DRC 01A के जवाब में किस फॉर्मेट में रिप्लाई देना है बताइए आप? पार्ट बी देने के बाद नेक्स्ट स्टेप क्या होगा?
और उसके जवाब के हिसाब से देखेंगे वाले हमको किस तरह से करना है।
मान लीजिए जवाब नहीं देता है,
नहीं दिया तो वन करना पड़ा मुझे।
और 1 किए तो समरी ऑफ शो कॉज नोटिस किए, शो कॉज नोटिस नहीं इशू। वो पहले शो कॉज नहीं होता है भाई। आप अभी तक जो है सो जो कोर्ट का ऑर्डर जजमेंट होता जा रहा है, आप लोग अभी तक पढ़े नहीं हैं, कोर्ट में भी अपेयर कर रहे हैं तो पता चल रहा है कि यू आर नॉट अवेयर स्टेप बाय स्टेप कैसे
यहाँ से जो जजमेंट हो रहा है।
All of you are retired.
Yes.
3 of them my lord chairman.
And all of them were posted in the Ranchi. तो अभी वो किस पद पे हैं आप? You are the present deputy commissioner. आपको पता है ना लॉ का क्या प्रोसीजर है, कैसे है बताइए, क्या करना है स्टेप बाय स्टेप?
सर सबसे पहले हम लोग प्रोसीडिंग स्टार्ट करके और नोटिस देते हैं, सुनवाई का पूरा सफिशिएंट मौका देते हैं, इसके बाद 01A करते हैं सर।
पहले हम लोग सर जब इन्वेस्टिगेशन स्टेज में पूरा प्रॉपर पेपर सबमिट कर दीजिए उनको नोटिस
वो सेक्शन 71 वगैरह डॉक्यूमेंट प्रोड्यूस करना वो हट छोड़ दीजिए आप DRC 01
ये देते हैं
हाँ
DRC 01 देते हैं और उसके साथ समरी दे देते हैं
उसके
क्या
साथ
क्या मतलब उसके खिलाफ में चार्जेस है उसका पूरा डिस्क्रिप्शन देते हैं
DRC 01A के साथ ही समरी भी दे देते हैं
सर वो समरी पूरा दे देते हैं क्या
तो
चार्जेस है
तो DRC 01A तो इंटीमेशन है
इंडिकेशन है क्योंकि सर हम लोग दे देते हैं
तो आप अपने
तो क्या चार्जेस
रूल में क्या लिखा हुआ है
01A
142(2)A में क्या लिखा हुआ है पढ़िए तो जरा मिस्टर करोगे 2A 142(2)A
Where the person referred to in sub-rule 1A has made partial payment of the amount communicated to him or desires to file any submissions against the proposed liability, he may make such submission in Part B of Form DRC 01. So DRC 01A attaches Part B notice itself, and in that either he makes payment or he can file an objection to that.
and then what does 142(1) say?
One level, the proper officer shall serve along with the notice issued under section 2 and 2 a summary thereof electronically in form GST DRC.
Yes. So no notice is there.
So here in this case, particular case, along with the DRC 01A, details focus notice was given to him and thereafter no reply was given by the SSC.
Why should a proper show cause notice be given along with DRC 01A when he is being intimated to pay the tax? If he doesn't pay the tax, उसका भी if he pays the tax, देखिए DRC 0
subsection 1A and 2. It says it starts from the beginning, where the proper officer may, before service of notice to the person chargeable with tax, interest, penalty under subsection 1 of subsection 3 or subsection 1 of section 74 as the case may be, communicate the details of any tax, interest and penalty as ascertained by the said officer in Part A of Form GST DRC 01A, and then where before the service of the notice of statement the person chargeable with tax makes the payment of the tax and interest in accordance with the provisions of subsection 5 of section 73 or as the case may be tax, interest and penalty in accordance with the provisions of subsection 5 of 74 or where any person makes payment of tax, interest and penalty or other amount due in accordance with the provisions of the act, whether on his own ascertainment or as communicated by the proper officer under sub-rule 1A, that is DRC 01A, he shall inform the proper officer of such payment in form DRC 03 and the proper officer shall issue an acknowledgement accepting the payment made by the said person in form GST DRC 02. Where the person referred to in sub-rule 1 has made partial payment of the amount communicated to him or desires to file any submission against the proposed liability, he may thus make such submission in form in Part B of Form DRC 01A. This is the.
So at the time of issuance of 01A, they say that they are issuing the summary of the show cause
It
notice.
is also in gist of acquisitions.
इस बार मतलब ये भी इनका हम एक बार काइंडली इसमें प्रोसीजर को इसी में कह रहे थे कि ये प्रोसीजर इनको समझाना बहुत जरूरी है अगर दिस इज द अंडरस्टैंडिंग इवन टुडे इफ योर लॉर्डशिप में काइंडली कम टू व्हाट दे हैव मेंशनड इन पेज 191 ऑफ द brief. Page 191 of this brief, this is DRC 01A, which they have given to me. And they say, case proceeding reference number so and so, intimation of tax of liability, intimation of liability under section 73(5) and 74(5). Please refer to the above proceedings in this regard. The amount of tax, interest, penalty payable by you under section 2 and 2 with reference to the said case as ascertained by the undersigned in terms of the available information is as below. Then that is struck. Second, you are hereby advised to pay the amount of tax as ascertained above along with the amount of applicable interest and penalty under section 74(5) by 9(2), paying which show cause notice will be issued under section 74(1). In case you wish to file any submission against the above ascertainment, the same may be furnished by ISNA in Part B of this form.
So 74(1) issue notice was not issued. फिर आप जीरो वन।
I am referring to this the same page number, which as per this number, the scanned copy of the order is attached now. The order which has been attached along with the DRC 01 is at page 211 now. 211 is the detailed order number.
Detail
Thanks.
at the stage of 018 detailed order.
Detailed order, how it can be?
There was an inspection.
Maybe.
So detailed order, Mr. Yadav, please, you also don't start talking in the same terms. You are a state council appearing before us and you know the law laid down by this court and other courts. Scanned copy of the order, where can be an order? Could be an adjudication order.
And just 2 lines after you are writing that show cause will be issued if you will not comply.
I just indicate to them, they, in what had used to happen, that is the notion which they are carrying. But under the erstwhile VAT Act, they had the power to make inspection. That inspection was under section 70, subsection 2 of the VAT Act. Even then, at that stage, they used to make mistakes. They made an inspection. They have the power to collect information, documents, everything, and then come to a conclusion whether a proceeding has to be initiated or not. And if they wanted to initiate a proceeding, a notice under 40 subsection 1 under the VAT Act, or the section 35 which used to be given for the proceedings to be initiated. Now they are treating the present proceedings when started with the search till the inquiry was completed at the stage when my friend is referring to that purported order which was in the order sheet, where they found a prima facie case against me on the ground that there is no document available with me. Now they are treating it to be a continuation of that, and then treating that now what we have done is 1A, we only gave you an intimation. Now you fail to respond. In fact, what your said from your lordship, I didn't want to be asked with them, but your lordship may see the purport of the order dated 14th August. उनका लैंग्वेज ऑफ ऑर्डर में कि आप पेमेंट नहीं किए हैं, इसलिए हम फाइनल DRC 07 निकाल रहे हैं। इससे ज्यादा तो क्लियर कुछ है ही नहीं कि 13 अगस्त का ऑर्डर नहीं बनाया। मेरे सर्टिफाइड कॉपी में 13 अगस्त का ऑर्डर हमको नहीं अप्लाई, मेरा मांगा हुआ मैं अप्लाई करके नहीं दे रहे।
One thing is clear, that your officers are not well conversant with the procedure under the Act. And that is why so many matters are coming before this court only with the same issue. And still the manner in which the officers are speaking reinforces this impression of the court that they are not conversant.
हम लोग इन्वेस्टिगेशन करते हैं, इन्वेस्टिगेशन का जो लिस्ट बनाते हैं सर, फिर 01 ए इशू करेंगे सर, उसको लिस्ट बनाना जो भी रहता है इसकी सर हम लोग देते हैं कि हम लोग इतना फाइंडिंग रखिए, इसमें क्या फाइंडिंग्स लिखिएगा, इसलिए सर हम लोग 01 ए के साथ सारा फाइंडिंग जो है वो साथ में देते हैं।
ठीक है
अगर वो किया सर
ठीक है। अब आप 01 ए में उनको कहते हैं कि ये जिस्ट है जो आपके खिलाफ में है और ये पेमेंट आप करिए, नहीं करिएगा तो 74(1) में शो कॉज नोटिस करेंगे। नहीं करने के बाद रिप्लाई फॉर्म बी में देने के बाद आप शो कॉज नोटिस जो कर रहे हैं वो 01 में कर रहे हैं, समरी में कंप्लीट शो कॉज नोटिस नहीं दे रहे हैं उसको। आप सोच रहे हैं कि आपने जिस्ट पहले बता दिया है इसलिए आपको प्रॉपर शो कॉज नोटिस नहीं देना, लेकिन वो जो लॉ हेल्ड हो चुका है उसके हिसाब से गलत, और आप शो कॉज नोटिस भी नहीं दिए हैं और 14 अगस्त को आपने DRC 07 इशू करने का ऑर्डर कर दिया है, और जो ऑर्डर को आप कह रहे हैं कि ये एडजुडिकेशन ऑर्डर है उसका कहीं रेफरेंस नहीं है और वो 13 अगस्त के डेट में दिखाया जा रहा है कि हम पारित कर दिए, और जब DRC 07 इशू कर रहे हैं तो उसमें 11 सितंबर का वो डेट ऑफ एडजुडिकेशन ऑर्डर दे रहे हैं। तो इतनी सारी गलती जब आप कर सकते हैं तो उनकी गलती को तो आप छोड़ नहीं रहे हैं, लेकिन अपनी गलती के लिए आप क्या कर रहे हैं? और कैसे कोर्ट, हाउ विल द कोर्ट बिलीव यू?
All of a sudden in the lockdown after a gap of 6 months, suddenly one day you have passed the order.
और मतलब जो ये DRC 01 देते हैं उसमें भी कोई डेट नहीं देते हैं कि on this even on the forget मतलब choker notice they have not contemplated as yet issuing of choker notice but in one also there is no date and there are 75 which is their opportunity of getting thereafter a notice that is also
all that we have indicated in our previous
but in case not your lordship
no in the previous order in your previous order that is why you see the purpose in elaborating on an order like this with me is that the officers who come to the court they may not be properly aware कि court क्या सवाल पूछना चाह रही है तो they can go through the order through the website तो आप आज आने के बाद भी you are not able to answer in fact you have a totally misplaced conception of how the procedure is to be
one very my attention.
date on which you deposited 1 lakh rupees?
On 29th January, the day on which this order was passed, on that day itself we have deposited.
We were laboring under the impression that this 8th March supplementary show cause is the one.
And we have also brought the letter that is dated 19/1/2021.
I think it's under. ये है ना?
I haven't got that. When have you filed?
On Friday, yes.
Then we keep it on any day after holiday.
In the morning, I was served coffee. And the so-called, I'm just placing before you. They have given only grade, how they have calculated that. And one representation given by this petitioner before passing of that order for opening of the shop, wherein this petitioner has only given a request, made a request कि मेरे दुकान से जो रिकवर हुआ था उसमें कोई भी गड़बड़ी नहीं पाया गया, जो दुकान के बाहर स्कूटी से मिला था उसमें कुछ अपमिश्रण मिला है, क्योंकि वो मेरा स्टाफ का था, उसको भविष्य में नहीं रखेंगे तो पेनाल्टी लगा के उसको छोड़ दिया. On that basis they have imposed 1 lakh penalty. And on the same day I have deposited thereafter unsealed. My shop was unsealed on 29th of January. These two documents have been brought on record and only they have given credit. They have not reconsidered on the point of that imposition of that ETD, ED and
Very well, let it come on 21st again. The supplementary show cause has been filed by the opposite parties on 11th March 2022. Copy whereof has been served upon learned counsel for the petitioner today morning.
yes.
Stop. Therefore, let the case be listed on 21st March 2022. The supplementary show cause be placed on record.
I think I had seen it in Fox. I had seen it, I didn't know.
Under the heading for judgment, item 1, PN number 36 of 2018, Mr. Nitin Kumar Pasari for the appellant, Mr. Amit Kumar, Mr. Rajneesh Kumar for the response.
Mr. Kurni is there physically today.
How are you, Mr. Kurni? All good?
So, we have given different opinions. So, I'll sign my own, the sister will sign my own. Today is 14th. Having considered the submissions of learned counsel for the parties and the materials on record, including the principles of law as culled out from the provisions of CA 1944 and the decisions referred to herein above, I am of the considered view that the order of learned tribunal cannot be sustained in the eye of law. It is accordingly set aside. The substantial questions of law framed for adjudication in this appeal are accordingly answered in favor of the appellant SSC. Let the lower court records be sent to the concerned tribunal and authority.
All the issues having been decided in favor of the respondent, there is no merit in the present appeal, which is accordingly dismissed. Need to sign on every page.
So that we will do.
Yes.
The last page
Yes,
we need
yes.
to announce. Since there is a difference of opinion amongst the honorable members of the bench on all the substantial question of law framed for adjudication, let the matter be placed before Honorable the Chief Justice for placing it before the appropriate bench in terms of Section 35G8 of the Central Excise Act 1944. Page 54 में sign करना।
ये सबको ना कंटिन्यूटी में रखना है
हाँ, ये
और एक पीडीएफ बना के अपलोड करना है।
pages are continuity.
हाँ, हम पेजेस इन कंटिन्यूटी बट पीडीएफ भी एक ही बनेगा क्योंकि एक ही साथ अपलोड
एक
होगा।
ही
दो अलग अलग पीडीएफ बना के नहीं अपलोड करेंगे।
और पेज नंबर।
हाँ, इसको कंसोलिडेट करके
Very well.